I'm immigration attorney Heather Poole. I'm speaking to you today about alternative options to filing for an immigrant visa under the Violence Against Women Act if you are an abused spouse. Always consult a competent, licensed immigration attorney about your case to determine your particular options. Sometimes a VAWA case is not possible for an abused spouse. This can be due to the abuser having lost his status as a permanent resident or U.S. citizen more than 2 years ago. The divorce may be more than 2 years final. The abuser is not a permanent resident or a U.S. citizen to begin with. Or the battered immigrant may have little bona fide marriage documentation or proof that she or he lived with their spouse. If an abused spouse remarries, he or she is also not eligible for an abused spouse green card based on a prior abusive marriage. If a VAWA case is not possible in these circumstances, there may be other options available to the abused spouse. The 2001 Trafficking Act amended the 1994 Violence Against Women Act and created 2 additional visa categories for victims of abuse and trafficking, called the T and the U visas. The T visa. The T visa is specifically designed for certain human trafficking victims who cooperate with law enforcement against those responsible for their enslavement. The statute allows victims to remain in the United States if it is determined that such victims could suffer extreme hardship involving unusual and severe harm if they had to go back to their home country. After 3 years in T visa status, victims of human trafficking may apply for permanent residency or a green card in the United States. In addition, subject to some limitations, the regulation allows victims to apply for non-immigrant status for their spouses as well as their children. Victims under the age of 21 may apply for these temporary visas for their parents as well. The U visa. Eligible candidates for the U visa must meet the following requirements. First, petitioners must have suffered substantial physical or mental abuse resulting from a criminal activity that is outlined in the statute. This usually refers to being a victim of violent crime such as domestic violence, rape, forced servitude, or battery. Second, the criminal activity must have taken place inside the U.S. or violated U.S. law. Third, the victim must possess information concerning the criminal activity. And most importantly, fourth, the victim must get cooperation from the police, showing that she has been helpful to a potential investigation or prosecution of the criminal activity. If the police are not willing to sign off on certification to this extent, she may also try the district attorney's office if the case was taken to trial or they considered prosecution. The S visa, sometimes referred to as the snitch visa, is for a person who has important information on a criminal organization and whose presence is needed by the law enforcement authorities investigating or prosecuting the matter. There also may be other family-based immigration options available if none of these previous options work. If you have a sister, brother, parent, or child who is a U.S. citizen or permanent resident, that person can sponsor you for a green card based on their lawful status. Similarly, if you escape your abuse and remarry a U.S. citizen or permanent resident, your new spouse could sponsor you for a green card. Note, however, that remarriage does eliminate the option of filing for an abused spouse immigrant visa petition based on abuse suffered in a prior abusive marriage. If this is your situation, please call us for more details to determine if this option is available for you. You may also have business immigration options. Your employer may be able to sponsor you for a green card through a process called labor certification. Labor certification can be a long process, and you must maintain lawful immigration status during the pending petition. And you have to show that there are no U.S. workers qualified to do the job that the employer is sponsoring you for a green card for. You may also have a shot at a temporary work visa. If you have a 4-year degree, you may be able to qualify for an H-1B, a temporary work visa issued on behalf of a company who hires you for a 3-year period, which is extendable up to 6 years with that company. These are the most common business visas used, but others are available. If this route is appealing to you, please contact us for more information. Lastly, it is extremely important to remember that you must speak with an immigration attorney if you are living in a controlling, abusive marriage with a U.S. citizen or permanent resident spouse, or you have been a victim of violent crime. There may be options available to you to maintain status to obtain a green card or even a temporary visa that would allow you to work legally in the United States. If you need my help, feel free to call me or fill out our consultation form on our website, humanrightsattorney.com. Thank you and good luck.